Okay, so we're taking the class forward from courts of records and courts other than courts of records. Recall that the first one we did or we examined under this classification is superior and what? Inferior courts. And of course, we made efforts to describe or to establish why some courts are superior courts and the others are what? Inferior. And then of course we're able to identify about four major differences which explain the fact that one court is superior while the other is inferior. But whether they are superior or inferior, they are both courts of the Federal Republic of Nigeria. So today we will take it further by looking at courts of records and courts other than courts of record. Now, formerly, a court of record was a court which kept a record of its acts and judicial proceedings. I said formerly, when we talk about court of records, we talk about courts that usually keep their records, the record of the activities, that is, the record of the cases that they attended to, which can also be referred to as judicial proceedings. Okay, so that is basically what court of record was known for. And court of records was also known for the powers which they possess to punish a person for contempt. So the question will be, what is contempt? So formally, any court that possesses the power to punish for contempt was referred to as court of what? Of record. Now the question then is, what is contempt? Let me explain it in a simple way. You always discover that the court is always a serene place, right? Where you are not expected to make noise because your noise can disrupt the course of the business of the court. So if you are in the court, for example, and your phone rang, let's even say it is all of these sophisticated phones that, you know, when iPhone is ringing, it's the ringing tone is with thieves, right? Not like the type that some of us have that can nearly wake somebody who is sleeping. You know, very loud one. You understand what I'm talking about now? I've used that kind of phone before, but my own is a bit better than that now. It's not there yet, but it's not actually by phone. Okay, so that action has created for some form of disrespect for the court. Okay, so the court will feel slighted that while the proceedings or the business of the day was going on, your phone rang, or you were discussing with somebody and then your voice was so loud that the court could not do its usual business. In a way, that is contempt. Contempt is also when the court gives you a directive to carry out and you refuse. So in simple terms, disobedience to court's directive is what? Is called contempt. So what led us to defining what contempt is that we said prior to this time, any court that possesses the power to punish contempt was referred to as what? Court of record. But today, the only essential feature of a court of record is its power to punish contempt. Okay? The only today, as of today, the only essential feature of court of record is its power to punish for what? For contempt. Previously, it was that if a court keeps the record of its proceedings, that court is referred to as court of record. But it has moved to a different stage to say, okay, yes, whether the court keeps its record or not, but once it has power to punish for contempt, then that court is a court of record. But one thing you need to know is that any court that will have power to punish for contempt will definitely be a court that will make keeping of its records as its usual and everyday practice. Do you understand the point I'm trying to make? So, therefore, today, any court which possesses that power to punish for contempt is a court of record. And any court that does not have powers to punish for contempt is not a court of record, meaning that it is a court order than a court of record. I hope you got the message. Okay. So a court of record may be a superior court or an inferior court. You can see now that we brought in superior and inferior courts together again, right? So what qualifies a court to be referred to as court of record is its power to punish for contempt. So if the court is a superior court or an inferior court, provided it can punish for contempt, then that court is a court of record. So, for example, the magistrate court, though an inferior court of record, has power to try a person on a charge of contempt. Do you know how contempt works? Sometimes when you commit contempt in the face of the court, right? Let's say, for example, as a judge, and you commit contempt there, they can ask you to be detained. Okay? And the court can ask you to come into the witness box and give reasons why you should not be sentenced. So the court does not need any warrant to arrest you. So that's why we're saying that any of those courts that possesses such a power is a court of record. And one example of inferior court that's a court of record is what? Is a magistrate court. Even though it's an inferior court, but it has power to try a person on a charge of contempt, where the offense was committed in the face of, where the offense was committed out of court. Example of contempt committed out of court is when the court gives you an order to do something, to carry out something and you refuse. It's not only in a class where people can refuse to do what they ask them to do. Some can also still choose not to do whatever they ask to do, even outside the court. So, if that contempt was committed outside the court, and this court can impose punishment, then that court is a court of record. So the power to punish for contempt is central to what qualifies a court to be a court of record and a court other than a court of record. Now let's focus on court of record first, which will also enable us to add more facts to the position that we have heard so far. Now, a court of record is a legal term. A court of record is a legal term referring to a court where the proceedings are permanently recorded and preserved for future reference. A court of record is a legal term referring to a court where the proceedings are permanently recorded and preserved for future reference. This court maintains an official record of all the actions, the testimonies, and the evidence presented during trial. Okay? The court keeps record of all the actions, the testimonies, and the evidence presented during trial or hearing. So the word hearing and trial also mean the same thing. So this record we are talking about serves as an authoritative account of what transpired in the courtroom and is typically used for appellate review or other legal processes. So, meaning that the purpose of recording is so that if there is need for the higher court to review what transpired in that case, the court will have what to work with. And that's why you see the judges doing some writing while they are what? They are presiding. Or is there anybody that has not been to the court before? Nobody? If you have not been to the courtroom before, raise your hand. You guys are so many. Why? No, there's nothing. You see, one of the things you need to understand is that you are here now, you are being trained to become mass communicators, right? Some of you now, you have not been to a studio, a new studio before, right? There are people who have not been there. How do you get inspired? Tell me, how do you get inspired when you have not been there? All you're just doing is just come to class, take note, and go. And you have a studio in your faculty here, don't you have one? As a matter of fact, I've been there. They don't allow people to come in. They have not been there. You should go there. You said what? You've been there. So you can also take a stroll to the court too. Just walk in, ensure that your phones are on silent. That's all. Sit down and listen to what the court is saying or what they are doing there. In fact, it's a way to give life to what we are teaching you. The court is a public place. Okay? So it is not only those who are come for a case, as you call it, that you see in court. You see people who want to observe proceedings. Many a times when the law students are on holiday, some of them they go to court as if they have a matter there. It's to give life to what, because when you see the way the lawyer talks, you see the way the lawyer make reference to a case, you continue to develop that interest, and then you have the what's it called now, the zeal to do better. So just take a walk. We have a court close to us here in Sabo, by they call the place Burial Street. That's close to LASEC. That's Lagos State Electoral Commission. It's just by barracks. Yes, I think barracks after Onike, right? Just walking into any of the court and feel free to observe proceedings. Yes. 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 Well, it can be in that way. If a court, some of us are very stubborn. Your phone rang, and the court said that they should seize the phone. What I'm supposed to do ordinarily is to plead for mercy, isn't it? Some will say, "My Lord, I'm sorry. I didn't know that my phone rang in a court one day too, and the court seized the phone." I was in the course, and then a lecture was supposed to start. So I was to start the lecture via my Zoom account. So when it was time, I just started the lecture. I didn't know that the lecturer was already there, and he spoke, and then the court heard. So before I could say Jack, the court has said he should collect the phone. And I told the court that I was sorry, I didn't know that the proceedings of court was going to stay longer than it was, because the class needed to start, and I was the person to kickstart it. And the court said, okay, that there's no problem, you should give me my phone. But some people will be dragging with the officer of court. I say, I will not give you, I will not give you. That kind of a situation can further provoke the judge. So if the judge is now provoked, the judge can order that the man should be detained. And if the court wants to do it, the court can ask the man to enter into the witness box and give reason why he should not be sentenced to prison. And then probably give room for any lawyer who wants to stand in for the individual to speak. But the court has that power. Or like when you want to go and make arrest, sometimes you need arrest warrants, right? But because the court of law possesses that power, it will do that without necessarily going through all of that. So the court can do all of that. As a matter of fact, there are people who are stubborn, who when the court is still talking, they are still talking back at the judge. And the judge are not, you may see them as human beings, they are not human beings. They represent the state. So it is actually the state that you are disrespecting, and the state has power to deal with such individuals. Okay? So let's move on. So like I said, this record serves as authoritative account of what transpired in the courtroom, and is typically used for appellate review or other legal purposes. So sometimes when a litigant is not satisfied with what has been decided, they have right to appeal, to go to what? Higher court. Now, one of the things that the higher court will demand for is the record of the proceedings that transpired in the lower courts. So there are some courts that may not have that record. They don't keep that record. So they don't fall within the class of they don't fall within the class that we call courts of records. Okay, so the court of records provide transparency and accountability in the justice system by ensuring that a detailed and accurate record of proceedings is available for reference. I will repeat that again, that court of records provide transparency and accountability in the judicial system by ensuring that a detailed and accurate record of proceedings is available for reference. By ensuring, sorry for the the technical issues that we're having there, by ensuring that a detailed and accurate record of proceedings is available for reference. We have examples of court of record. Who can think of what of them for me? Number one. Yeah, Supreme Court is one of them. And we said the Supreme Court is the highest court where? In Nigeria. We also have Court of Appeal as an example of court of records. We also have High Court of the various states, and also High Court of the Federal Capital Territory. You know, the Federal Capital Territory is not a state, so it also has its own High Court. Just the way we have Lagos High Court, we have Delta State High Court, we have Ekiti State High Court, we have Anambra State High Court. Which state are you from? Benue. We have Benue State High Court, and so on and so forth. Which state? What? You have a question? All right, go ahead. Can we have one house, please? Class, let there be peace. Yes, please. Yes. Okay, she's asking that the records of the courts, are they also what related to judicial precedent? Because they sound alike. Yes, to an extent. Now, when we talk about record of proceedings, the court will write everything that transpired. But when they want to give judgment, you know, it's not everything that will be where? In a judgment. That's why we said we have ratio decidendi and what? Obiter dictum. And some of you wrote just what you feel under those things in your text. But majority wrote very good points on ratio decidendi, reason for the decision. Some people they went as far as saying that obiter dictum is what the court feels. Some said, I'm trying to remember the exact. In fact, some people said obiter dictum is judicial precedent. God will help those people. All right, so why the record of proceedings are being taken? It is from the record that the court generates its judgment. So that judgment constitutes what? Case law, which is also the same thing as what? As what? As judicial precedent. So when we are talking about judicial precedent, there's no way we can talk about judicial precedent without talking about court of record. Because if the records are not kept, it will be difficult for the court to produce its judgments. Okay? And one of the reasons why the records need to be kept is that even though our judges are expected to know everything, but the truth of the matter is that there is no man that knows it all. So if after the judgment has been delivered, a party feels that they made a very good point in the course of the trial, which the court recorded, but the court did not use it for the judgment. If they appeal, it is that court of record, that record of proceedings that the higher court will look at. That is it true that they made these points, which the judge that was sitting over the case omitted. So the court, in a process of doing justice, will make effort to do what? To look at the records in order to be sure that justice is done. So the last example for court of record is the Federal High Court. So can we list the examples of court of record that we have given? Number one, followed by after court of appeal, and the last one. Okay. So now let's look at inferior courts. Inferior courts. What we just looked at now is what? Sorry. What we just looked at is course of record. At least it shows that you are following. I'm sure some people will have even written inferior course here now. Those who are just here physically and their mind is not here. Alright, so we now look at non-course of records. So a non-course of record, also known as a course not of record, is a legal term. A non-course of records, also known as a course not of record, is a legal term referring to a judicial tribunal where the proceedings are not permanently recorded and preserved. We repeat again that a non-court of record, also known as a court not of record, is a legal term referring to a judicial tribunal where the proceedings are not permanently recorded and preserved. So, in this court that are not courts of records, the decisions and proceedings are often informal, and there is no requirement to maintain a detailed record of the hearing or trial. Do you understand that point? The position is that the court does not require them to do so. Like, for example, in a customary court setting, where practically everything is done, let's say, informally, unlike the normal Supreme Court where you have to abide by all the rules, you have to follow the procedure, and so on and so forth. In some courts, these rules are relaxed. So, like, we have tribunals that they are established for a particular purpose. They are relaxed courts. So, the court or the law of the land does not require that every of their activities must be documented. So, those are the courts that we refer to as non-court of record. So, non-court of record are typically used for handling minor legal matters. They are used for what? Handling minor legal matters. Such as what? Can anybody give me an example? Land disputes. Land dispute is a serious matter. It's a serious matter. So it doesn't fall under this example. Yes? Common text. Yes? I heard something that, what? Traffic offenses. Very correct. Yes? Which other one? What? Klepto? Okay. Alright. So examples include traffic violation offenses, small claims, or administrative hearing. Small claims or administrative hearings. So another point we need to note here is that unlike court of records, the decisions made in non-court of records are usually subject to review. Okay? Like I said, unlike court of records, the decisions made in non-court of records are usually subject to appellate review based on a formal record of proceedings. Okay? They are usually subject to what? To appellate review So because it's very possible,
Maybe you put this thing on top, maybe you can reduce it in print. Okay, let me. Yes, try. So that it will reduce.
okay, are you following me? So I said on like court of record, the decision made in all court of record are usually subject to appellate review. But one of the things you also need to note is that we have established that court of appeal is a court of record, isn't it? But do you also know that decision reached in court of appeal can be appealed to the Supreme Court? So it doesn't make court of appeal a court not of record or court of no records. But basically, majority of people are likely to be dissatisfied with the decision reached when you're talking about tribunals, talking about administrative hearing and things like that. For example, if you are a student in Unilag, for example, and you violated your matriculation oath, you went against it, you did nothing nasty, and then they have to set up a panel for you. That panel is what we can refer to as administrative hearing, where they will call you to say your own side of the story, right? Which they can also do the same for even lecturers. So all of those decisions that may be reached there, they are not decisions that you can classify as final decisions, isn't it? Because most times people will feel that justice has not been done. So therefore, let me go to the courts of law, where we have people that don't know me, neutral people. Because if they want to set up a panel for anybody here now, you probably pick one of your lecturers. And you say that lecturer, anytime I greet him, he does not answer. How is he going to do justice in this case? So that's why all of these administrative hearing, all of that are classified under this. Their decisions are likely to be subjected to review, because most times the issues cannot be dealt with the way it will be done at the highest court of the land. Okay? So examples of non-court of records include: number one, traffic courts. Traffic courts, small claims court, small claims court, administrative hearing, tribunals, and last but not the least, magistrate courts. So before we move to another topic, let's look at the key differences between courts of records and non-courts of records, just the way we did for superior and inferior courts. So it's also important that we look at this under this topic. So number one major or key difference between court of record and non-court of record is the level of formality. Level of what? Formality. Number two, the power to fine or imprison. Like the administrative tribunal I talked about, irrespective of what you have done, they cannot send you to prison, right? Because they do not possess the power to do so. Then, number three, maintenance of a permanent record is another key difference. Maintenance of a permanent record. Number four, the ability to appeal decisions. Okay, the ability to appeal decisions. So, court of record are typically more formal and have more significant powers, while non-court of record are often informal and have limited power. So that is an addition to the fact that we have established. But what are their similarities? Number one, similarities between court of record and non-court of record. Number one is that the main similarity between a court of record and non-court of record is that both are types of judicial courts. Is that both are types of judicial courts or tribunals where legal matters are adjudicated. Okay, both are what? Types of judicial courts or tribunals where legal matters are adjudicated. Number two similarities is that they both have the power to hear and decide cases. They both have the power to hear and decide cases within where they are during their jurisdiction. And the third one is that both courts aim at administering justice. Both courts came to administer justice according to law and a various principle that leads to justice. So those are the similarities between the two types of courts. Okay, so now with that, I think we have a summary on that. So in conclusion, court of record and non-court of record are essential components of Nigerian legal system. Okay, so if you are talking about Nigerian legal system, there's no way you will just have to refer to court of record and non-court of record. Each of them serve distinctive or distinct but complementary roles in administering justice in the country. And of course, we've seen the major differences they have. Those differences are particular about the purpose for which they have been set up or established. So, with that, we have covered courts of records and non-courts of records. Okay, all right, so we're going to stop there for today. Can we take questions? Can we take questions, please? Yes.